Good morning, everybody. Just to give you a bit of a background and sort of full-on introduction to Devasys. Devasys was a business I created 10 years ago. It was based upon my experience in development. When I started my career, I worked for large national house builders, and I was very specifically in the land team. It was my job to basically go out there, identify development opportunities, take them through the planning system, and then generally upset all the communities that are out there. Development is not popular. Over my career, I've been spat at, sworn at, hate campaigns. There's a lady who's currently working for a very large developer, and I know that she's recently had some death threats. So when we refer to the British public as sort of NIMBYs, it really sort of scratches the surface. They really do hate development. So my epiphany 10 years ago was to create a business which could educate people about where these development risks are. And that's what we do, is we effectively audit locations, but we go well beyond the sort of the standard planning data that's available out there. Planning data is part of our research, but that's only one part of it. I always sort of say it's a little bit like going to the doctors. If you went to see the doctor, you wouldn't want the doctor just to take your temperature. You would want to look at everything possible and all the sort of the tools, the MRIs and all the other things available. And that's what we do, is we don't just look at planning data, we look at policies, we look at emerging sites. And these are some of the slides that I want to take you through. The bad news for the British public, as much as they hate development, they've got lots of it out there. I have never in my sort of 30 plus years ever seen a system that is so pro-development as it currently is. And part of that is because of this document, the National Planning Policy Framework. This was, in my eyes as a developer, a game changer. Prior to this document, if I ever went to see a planning officer, and I've had this with planning officers, if I ever went to put forward a site for development, I was pushed back once with, I don't know why we're having this meeting, over my dead body will you ever get planning on this site. If I was to see the same planning officer today, she would have had to have started the meeting with, welcome, sit down, let's talk about how we can get you planning on this site. So it's a much more proactive approach. There's a second element to this, which is the 5-year housing supply. And this has perhaps been a bit of a misunderstood part of it. Every council in the country now has to have an auditable and defendable 5-year housing supply. So the first thing they're going to do is have a housing needs survey to understand how many houses they need to provide over the next 5, 10, 15-year periods. What they will then do is look at all of their unbuilt planning. And so let's say, for argument's sake, that there was a target, and it was perhaps the Cotswolds District Council, and let's say they had to find 5,000 homes for the next 5 years. They'd look at their unbuilt planning permissions, and let's pretend they find 1,000 plots. They would then look at their allocated sites, and they might find another 3,000 plots. So they're up to 4,000, but they are still missing 1,000 plots. If they don't find them, then the presumption is technically in favour of development. And this is why we have seen over the last 10 years so much more greenfield development than I've ever seen in my career. Because if you have got a council with a 5-year supply that is less than 5 years, lots of hostile developers will be putting in these applications on greenfield land. And it doesn't matter whether they're in areas of outstanding natural beauty or greenbelt, a lot of them have got planning permission. I should say, for clarity and honesty, it doesn't always follow that they will definitely get planning, but it has exposed an awful lot of greenfield land, more than I've ever seen before. And this was an example of it. At the time this application went in, Cornwall didn't have a 5-year supply, and the office report said that we basically cannot defend it, and a planning permission was granted for 50 houses. Now, it doesn't matter how pro-development I am, I think that's a ghastly planning permission, because it really is, you know, an urban development being built in the middle of the countryside. It's not good news, but it is something that we're seeing across the whole country. Another part, and if we go back actually to the missing 1,000 plots, Cotswold District Council, they found 4,000, they were missing 1,000. What they do in all these councils is they have a call for sites. It's a massive consultation and an invitation to any interested party, landowner or agent, to submit land that they feel is suitable for development. And then it will go through the strategic housing land availability assessment. You do get variations of this. You do get SHLAAs, which is a strategic housing and economic land availability assessment, or just SHLAAs, which are land availability. They're all pretty much the same thing. But what they do is firstly, they expose that you've got a willing landowner, a landowner that is motivated and quite excited at the prospect of putting forward their land for development. But the council will assess them. Some will be dismissed, but some will be identified as suitable and developable, which makes them quite a high risk site, because it's likely that if they were submitted for into policy, perhaps for promotion to become an allocated site, clearly the council have already identified that they feel that they're suitable. So they're very much the genesis stage of development. And this is an example of them. This is down in Chichester, down in the south coast. As you can see on this slide, everything coloured green has been identified as developable. So you can see that there are massive, massive waves of swathes of virgin green land that has already been identified as suitable. Now, if you buy planning data, these sites will not be identified, because planning data is only as good as the activity of an applicant. If no one has ever yet submitted an application for development, then that data will not be harvested. So this is why looking at these strategic housing assessments is so, so critical. And it's the USP of our business, is that we look at them. In fact, we are totally, utterly unique. We are the only company in the country that does this. So if you want to look for at a SHLAA to see if there's land nearby your client's purchase, you have two choices, which is one, to do it yourself, or secondly, to employ us. As I say, the only people out there. And this is just a random selection from Birmingham. But I think what I wanted to draw your attention is on the top row. If you go 4 in from the left, you will see a site here which was identified. It was found suitable. It was found available for development, but it is currently in the local plan also identified as public open space. So nothing is off the table. All land is vulnerable for development. And this is a very, very small selection of the sites that are available in Birmingham. And also of note was the fact that Birmingham do not have a 5-year supply. So they're sort of double vulnerable. All sites technically would get a presumption in favour of development. Now, this was actually a report we did this morning. So this is sort of hot off the press. And I just wanted to show it to you, because the property in question, if you look to the aerial image, it was actually a property that was abutting Greenbelt. It was one of the properties just above where you can see that postcode. Lovely views. And I went onto the web and I found the property where it was being advertised. And this was the estate agent's description. It says, tucked away with fantastic countryside views. But then if you look to the slide in the middle, it's already been identified in the St Albans SHLAA, identified for over 1,000 plots. And found to be suitable. If you look to the top right, you can see it got the green pass on every single category. So that is a very, very significant risk. And it's just a very natural settlement expansion. And obviously edge of settlement is always perhaps the most dangerous place to buy a property, because that's where they're most likely to expand. So we would have in fact identified that as a lending risk. When we say lending risk, we're actually saying refer this back to the valuer. The valuer must have the last word as to whether that impact and that loss of that view is going to change the value of that property. This is a very high value. It was a very, very expensive Grade 2 listed mansion in Windsor. It had quite a large acreage that came with it. The road that was in front of it actually fell within a neighbouring council, which wasn't Windsor, it was into Bracknell. Bracknell don't have a 5-year supply. But what we found was that the land directly opposite had also been identified in the SHLAA, found to be suitable, found to be developable, and Bracknell don't have a 5-year supply. So land that was very, very vulnerable to a planning application, and the planning application actually that went in was over 2,000 plots. So unless you look at these land availability assessments, you will not find them out, and they often go unnoticed. And I've only actually found 6 solicitors in the country. I'm sure David's going to be my 7th who have actually heard of them, and 2 of those were actually planning solicitors, so I would have expected them to know. But it's a very it's a document that lots of people just do not know it ever exists, so they are critical to investigate. Back into Tandridge, just south of Croydon, again, public open space. This is land that's owned by Tandridge. Tandridge are desperate for development now because for years they've been trying to say no, but now they're being forced to say yes. And as you can see, achievable development of this site is considered to be achievable, deliverable, can be developed within 5 years. So as I said, nothing is off the table. Again, 2 SHLAAs here. You can see how the views to the northeast and the southwest would have been impacted. But what the viewer saw when they went to spend 5 minutes viewing the property before they committed that they were going to buy it for whatever, 600, 700,000 pounds, what they saw was lovely views over open land. But as you can see from the image on the top right, likely to be deliverable, there were 2 high-risk sites there. Sometimes sites get rejected. And we also include these and we would still report on them. They wouldn't carry as high a risk. They would perhaps be a low medium risk, a low medium because we've clearly got a motivated landowner, but the council have rejected it. So therefore it's not an imminent risk. But SHLAAs are, or a call for sites it's an invitation which is repeated. So whilst it may be unsuccessful in this particular stage, it could be submitted again next year, the year after that, and at some point it could be found suitable. And edge of settlement at some point you've got to see, and as you can see here, there is actually a very natural rounding off to this particular settlement. So I would still see that as a vulnerable site. So it's looking to educate people on what could change in their location. When you get into the big city centres, a lot of people think, well, they're all intensively developed, what could change? But of course, existing buildings, we are probably one of the oldest recycling industries because we always take down buildings and replace them. I've seen buildings that are only 30 years old in London be knocked down and replaced with something bigger. So as you can see here in Sheffield City Council, whilst we've identified that the subject land obviously had development potential itself, but there was a staggeringly high amount of planning activity in that location. So this is where the planning data comes in. We will go through that planning data and extract what is relevant. What is irrelevant is you don't need to know about an application for a porch or a conservatory 500 meters away. And that's the trouble with planning data, is that you really are looking for the needle in the haystack. And that's what we do, is we take that stress away from the solicitor and the client, and we will go through that planning data and extract what is relevant. Added to which, if we find something that's relevant, we will attach the evidence. So if it's been in the SHLAA, we will show the evidence in the appendix to our report. So we will attach the images. In this case, we had CGIs. So we're always attaching something that's very visual and visually easy to understand, because it may well be that your client may not understand reading plans perhaps as well as we would. Here we go back into Birmingham, and again, as you can see from the sites that we've marked in red, we found 5 sites, one of which was the subject land, subject property, which had itself planning history, but then we did find an additional 4 sites with live planning applications that would be relevant and would have an impact on that property. So we would include those, and again, London boroughs, again, huge amounts of planning activity. I've touched on the edge of settlements, but this demonstrates quite clearly how vulnerable they are. Everything coloured green has been an accepted site in Hereford. So it's the natural, but towns are just like balloons. The more air you put in the middle, the more they expand. So edge of settlement is always a vulnerable location to look for either allocated sites or sites that have already been put forward into the call for sites land availability assessment process. And this is why I think it's so important. A very professional firm. I'm not going to be in any way negative about Bird & Bird. Quite the opposite. I would see them as a highly professional firm. They were employed to buy it was a commercial transaction. It was an investment property in Camden. The story was that Rebecca Chow, who owned a BVI registered company, wanted to purchase an investment property. She found one and she had agreed to buy it for £25 million. She employs Bird & Bird, Bird & Bird being the great firm that they are, wanted to do a very thorough job. So they bought every possible search report they could. One of the reports they bought was Landmark's Plan Search Plus. And this is the mistake they did make. They went through that planning data themselves and then reported to the client that there was nothing of concern. They then made the second mistake of not even emailing that PDF document to the client. Client then went on to exchange contracts, finds out that a nearby college was evolving into an academy. The student count was changing by 700 students. It was literally doubling in size. And she decides that that's unpalatable and doesn't want to proceed with the purchase. So she's now out of pocket for her deposit and costs, and she sues Bird and Bird and successfully wins. Bird and Bird then tried to defend that and appeal that decision, but lost. So there was it was nearly a £2 million professional negligence claim against them. Had they have done the simplest of things, which was to email that Plan Search Plus document to their client with the words that this is outside our scope of works, please read the attached and advise us whether you're happy to proceed, then they'd have been off the hook. So big mistake. But this is where I have my little smug moment, is because this property had to be resold, and it was actually resold to Elizabeth Murdoch. She agreed to buy it for £28.5 million. Which I think is very relevant when you think of the damages that were awarded. The actual investment would have climbed by over £3 million had Rebecca Chow gone ahead with the purchase, whereas she was awarded damages of £2 million. So to some extent, the damages were self-imposed. But this is the property in question. This is where it is, where you can see the arrow, and you can see the college to the north. And that was the college that was evolving into a 1,400 student academy. I don't think that would have had a jot of difference on the value of that property. In fact, it's quite common that good education adds value to locations because people find it more attractive. But what was interesting in the claim was that they didn't identify 3 other sites. The property next door had planning consent for demolition and replacement. The property next door to that also had planning permission for demolition and replacement. And the property directly opposite, on the opposite side of the road, also had planning for a very large development. These were 3 additional sites which we did report on to Elizabeth Murdoch before she went ahead and proceeded to purchase that property. They would have had a much more significant impact on that property than the college to the north, but the claim was still successful just based upon that. In fact, the judge actually felt it was not for Bird and Bird to decide what is an acceptable or unacceptable planning permission. That was up to the client. So this was the exact report that we sent off to Elizabeth Murdoch's solicitors, and as you can see, front cover of the report marked it as a high risk. Are there major planning applications of concern? Yes. Are any views going to change? Yes. Is the immediate area under threat from development? Yes. Is there a risk to a lender? No. So absolutely nailed it. So there we go. Well, that's the end of my smug moment. This particular one here, we actually had the end user client pick up the phone to us, and he was devastated, absolutely devastated, because he and his wife had fallen in love with this beautiful property in the Cotswolds. It was within the area of outstanding natural beauty. And it had beautiful views to the west, to the north, to the south, all over open fields. We found that the land had been identified in the SHLAA. It was found to be suitable, available, so it's gone up to a significant risk and a very good chance, because if you look to the aerial image in the bottom right, you could see that by developing on that field, it's a natural rounding off of the settlement, which is something that local authorities look for when settlements expand. But the one thing that was interesting was that this particular client was thrilled with the service level that his solicitor offered, because without this report, there is no way they could have found out that that site was identified in the SHLAA and suitable for development. So he got a full thumbs up for the client, but we were obviously able to send him off with basically enough information for them to make a grown-up decision as to whether they go ahead and proceed with that property. Public open space, again, is not suitable. The clients here thought they were buying the property at the end of a cul-de-sac, a lovely place perhaps where the kids could go out on their skateboards in front of the property. But here, whenever I see the end of a cul-de-sac, I see the start and the entrance to a whole new development. And that's exactly what happened here. Now, this was originally public open space, which was handed over in the Section 106 agreement to the council, but then the council was in such a need for further housing, that they re-looked at it and decided that they would extend that cul-de-sac in and build more houses. So again, the clients, before they purchase, can find out that actually this is not the property they saw and fell in love with when they spent 5 minutes viewing it. It's not always necessarily development risk. We've had change of use applications into drug rehabilitation centres. We would report on that. In this particular case, we found that the land at the rear had been identified as suitable for a permanent gypsy traveller camp. Now, the rights or wrongs of arguing this is a debate for another day, but I will just make the valuation fact that because of that, all the properties in this area will be dropping in value and losing a considerable amount of their marketability. So a critical bit of information that we would report on. We buy in planning data on your behalf, so you no longer have to read the planning data. And I think planning data it's not like other searches and reports where you will actually be given a pass or a fail. It's very subjective planning data. You've got to read it all and decide which bits of it were relevant. But really, do you want your client to take that responsibility themselves? I always think, again, using the analogy of going to the doctor, if I went for an ECG on my heart, at the end of the consultation, I would not want the doctor to turn around to me and say, oh, I've printed off the ECG, here it is, take it home, have a read, let me know what you think. You would rather the expert goes through that data themselves and tells you what is relevant. And that's exactly what we do for you and your clients. We extract what is relevant, and if it is relevant, we attach the images so it becomes an evidence-based report. It doesn't matter whether your preference is towards landmark, future climate info, or ground shore. It's entirely up to you, or whether you just leave it up to us for us to decide which is the better planning data at the moment to purchase. We do a commercial property. Commercial is very different. It's not as emotive as perhaps Mr. and Mrs. Average buying and falling in love with their dream cottage in the countryside. But with commercial, it's really, is there something that's going to impact the business? And this was quite an interesting one we found in Piccadilly Circus, just north of, just at the bottom there where it says Piccadilly Circus, that's where Eros is. So it's a really dense part of the West End. 3 sites identified, but it was sites 1 and 2 that was of relevance. The client was taking a restaurant lease and their solicitor commissioned one of our reports. We found that sites 1 and 2 had a live unimplemented planning permission for a mixed-use development. It was going to be a leisure-led development. There was going to be some employment, food, etc. So this was actually great news for the incoming tenant, because clearly more people being attracted to this area is potentially more bums on seats at his restaurant. But the part that we found was relevant was we actually went to the planning permission for sites 1 and 2, which was actually a combined site. And it said that there was going to be a road closure for 6 months. So now suddenly there is nobody passing that property for 6 months. That could have a huge impact on cash flow. Is it any viable, or is it just simply a renegotiation to change the possession date to once the road has been reopened? So a critical bit of information that we found prior to the lease being signed. What is more staggering is that over the last few years, going back to 2018, at the beginning of every January, we go back over the previous year and we go through the thousands and thousands and thousands and thousands of reports that we've done in that year. And we work out how many of them had 1 or more high-risk sites within 75 metres of the subject property. And we've had a very, very consistent, the lowest it's gone is 29%. Last year, it was at 31%. So it really is a staggeringly high hit rate. Doesn't mean it's a deal killer. We're not here to kill deals. We're just here to give people all the information so that they can make that informed decision before they go ahead and purchase the property. This one stands out because it surprised us. In fact, it surprised me personally so much that the following day I actually drove down to Folkestone where it was, because I wanted to see it in person. What we had was a fairly modest value flat in a grade 2 listed converted terraced house. It had views to the rear and views over the beach in front of the property, and obviously sea views beyond that. We did have investigations. Firstly, we found that the car park to the rear had already been identified in the SHLAA as suitable and available. So firstly, there's our first risk that we found. But the one that really surprised us was the beach. We found that the beach had an unimplemented planning consent for over 1,000 flats. Half the beach was going to be developed, and the remaining half, which would have been in front of those flats, which was obviously going to remain a beach. So the sea view was going to be lost. Now, I just felt that there must be some clue on site, so which is why I drove down there. I was looking for either a site acquired by Taylor Wimpey Homes, or perhaps land for sale with planning consent for large development, or perhaps the smallest of signs would have been a planning notice attached to a lamppost. There was nothing. There was no visible clues in front of that property that that land in fact had an unimplemented planning consent, which was clearly going to block that view. We would again have said this must be back to the valuer. The valuer should have the last word on this, if indeed your client still wants to proceed. Water is not safe. We've got numerous examples of where water is being either reclaimed or something's being floated in to change a view. In this particular case on the Dartford estuary, the original developer who built this luxury block of flats and no doubt sold them with water views was going back to look to reclaim the water in front and build in front of the flats that they sold with water views. So again, it just allows people to hit the brakes and make that informed decision as to whether they still want to go ahead. Clearly, if they were at the back of the development, it may not have an impact, but if they did have that water view, I would definitely want to know about it before I purchase that property. When we get into London or any other sort of major city, Birmingham, Manchester, etc., you're looking for different types of risks. We do have different types of reports for different locations. I will come on to that in a bit. But when you get into, in particular, London, you're looking not just for new build structures that could impact a property, you could be looking for property modifications. The most common of which we see, certainly in the West End, is basements. And the scale of these basements are huge, which is why they refer to them now as the iceberg homes, because there's more underneath than there is on top. Now, they can have a critical impact on the property. You would want to know if there's going to be that level of construction near your multi-million-pound terraced house. So we're looking with our Dev City report very much for property modification, high-rise structures. The other very common one we see all over the country now is where you've got flats with flat roofs, and we're seeing lots of applications for lightweight structures on the roofs to put on another story, 2-story. There's one in London, in fact, where they added an additional 15 stories to a 30-story structure. So it's amazing what these architects can now do with modern engineering. On the left here, you've actually got an extract from the local plan. You can see that the overground railway system, that would form part of your TfL map for London, but you can see it's edge red, and why? Because it's an allocated site. Well, how do you allocate a live railway as a site? Well, it's very easy. It's in a cutting. You put a slab across the top, you turn it into a tunnel, and then you build on top of that slab, which is now a very high value piece of real estate. Now, you can't get away with that in Norwich or perhaps Plymouth. You just won't have the exit value per square foot to justify the build cost per square foot. But in high value Birmingham, Manchester, Bristol, this is where you will start to see these type of applications. And this is why basements are very important. This is a true story. It was a house that was once owned by Duffy. She sold her house, and the incoming purchaser decided to put in a basement. They got planning permission, they brought in the building team, and this is what happened when they started the excavation. The whole structure fell into the new hole that they were creating. The question I want to pose to you is not if your clients have just bought this property, but what if they had exchange contracts to buy the abutting terraced house? That is now an unsafe structure. It's structurally questionable. Will the bank, building society, still advance the completion monies on completion day? Highly unlikely, knowing that the security is has been diminished. So it's a critical bit of information to find out prior to exchange, and you've also then got to look at what's the insurance validity of the developer who was actually carrying out the works. And they are surprisingly common. This is in Eaton Square, an incredibly valuable piece of real estate in London. And on this particular property, we found 2 live unimplemented planning permissions basements. And you can see from the middle image there, the depth that that basement was going. It was actually adding 4 stories underground with a swimming pool on the bottom fourth story. And then the other party wall also had an application that would have affected it. So they're going deeper than the original foundations of this property. And they're also listed structures. So incredibly important prior to exchange that this information is shared. Now, perhaps of all the slides I share, this is hopefully the one that will stick with you, because this is a true story of one of our clients in East Anglia, who was aware of our service and in his client care letter would say, option A, please give me so-and-so pounds and I will commission a specialist report from Devassist that will do X, Y, and Z. Option B, if you do not want to give me so-and-so pounds, I will commission some Plan Search Plus from Landmark, but you will be responsible for reading this data and telling me you're happy to proceed. Option C, do nothing at all. The client went for option B, drew a line in the middle. And the solicitor, quite rightly, because of that Bird and Bird case, sent on the planning data to the client. She decided to go ahead and proceed, and then finds out that on the opposite side of the road, this 3-story education block was going to be built. And that's what you're looking at here is the before and after. And she's miffed. This is her genuine letter of complaint to the same solicitor, and it reads as follows. I was shocked to receive a letter from Churchill College about planned development on the site opposite my new home. Discovered that a planning application was made January the 14th. I checked the search about planning applications you supplied March, copy enclosed, which made no mention of this. The consequences of this development is that I will lose the wonderful view I have from my house. I will supply photo in due course. What happens? That is not a client that is saying, on reflection, I should have gone for option A. I should have read your client care letter better or properly. It's my mistake. You've done nothing wrong. No, this is someone who's still holding the solicitor responsible. I asked him actually if he could send me the planning data that he actually sent to his client so that we could do a retrospective report, because I wanted to find out whether she was correct in saying that it made no mention of this. And she was wrong. The planning data did reveal it, but there's a reason she may have missed it. It could have been, A, she lost the will to live reading the planning data because it is just pages and pages and pages of planning applications that all look the same. Or was it because the council had geocoded that application to a different location? Every single planning application at the moment is currently geocoded to an XY point. And what the council had done is that they had geocoded it to the applicant's address, which was in fact 220 meters away to the northwest, where in fact the development site that they were looking to build the education block was actually 20 meters to the northeast of the property she was buying. Now that's exactly what we would have picked up because we know how to read planning data. So we would have found it, she would have been aware of it, she could have then made an informed decision. More importantly, he would still have a client that's not going out there saying bad things about his firm. These are the products. I'm just going to very quickly show them because I wanted this to be more about education than it is about sort of a sales pitch. So I'll just be very, very quick here. In a perfect ideal world where your clients are not cost conscious, Devassist Premium should be the go-to report. It's for larger residential, larger commercial, up to 40 acres. Principal difference between that and the more basic Devassist is that it will study 75 meters from the boundaries of the property, whereas Devassist is a 75-meter radius taken at the main structure. So sometimes on larger properties, 75 meters doesn't even reach the edge of the or the demise of the property. So in a perfect world, Premium, these are reports that retail at £300 plus VAT. That includes the cost of the planning data. but the premium goes into a lot of detail. It will look at the council's 5-year supply. It's very much looking at detail for the strategic housing land assessments, gypsy traveller sites, changes to infrastructure, and are very evidence-based. Everything is backed up with evidence. Dev Assess, I don't want to talk it down because it's still an incredibly powerful report. It's available. The RRP is £100 plus VAT. Again, that covers the cost of the planning data. But generally, I would say if you've got risk-averse clients, go for the Dev Assess Premium. If they've got an appetite for risk, then they can just go for a Dev Assess. But high-value central city locations, I would encourage going for the Dev City. It's £500 plus VAT. It's updated free of charge before you exchange contracts, because sometimes, as we know, there could be a lag between heads of terms and actually being ready to exchange. So we look to see if anything has changed. And it's looking for not just new build, but it's also looking for property modifications. I should add that Dev Assess and Dev Assess Premium will also look for property modifications, but only on abutting properties. So neighbouring properties where perhaps somebody could be buying a 3-bed semi and the abutting semi is just put in an application for a 2-storey extension. We would cover that. It's not just new build development that developers are proposing. So they're our principal products. Turnaround times, Dev Assess Premium, we generally try to turn it around in 3 days. The other reports are all 5 days. We do have an option where you can fast track for an additional fee, which basically queue jumps it to the front. I'll just share with you one final comment. It was Brendan Morehouse, who's a planning barrister down in Bristol. Perhaps David might know him, but when he became aware of our services, he said, I suspect that your services will become a standard requirement for all solicitor conveyancing searches. So that's the day I'm looking forward to. But that's me. I've done my bit now. So hopefully that all makes sense. I don't believe I've got any questions yet, but I'm happy to, obviously I shall be hanging around and happy to take some at the end. But for my part, thank you for listening. And now I'm going to hand you over. I'm only the warm-up back now. Now we hand over to the professional of David. So over to you, David.
Thanks, Paul. I have to say that Paul's not wrong in his assessment of, I think, perhaps the necessity to get these things, and also reading into what he described there, that the three-way choice of the full product or the halfway house, or just providing the data or not doing it at all, has more pitfalls than it looks like from the initial, and perhaps one should pick either the full product or the not at all as the two options. There was yet another case for poor old Withers that was only issued, I think, this month or last month. It wasn't exactly planning, although planning was involved. They answered off the cuff a question from their purchasing client about an electricity cable that across the property, saying, well, it's got a way leave. They didn't go on to say, but if the way leave had been there for 15 years, you could apply to have it moved. They didn't go on to say that extra sentence, and the clients pulled out and sued them for their costs and losses, and with his lost. It's a sort of salient example in that you don't try and guess, don't try and do something off the cuff. You're either doing the full thing or you're not doing it really. And also picking up on Paul's comments about SHLAAs, I do know what the SHLAA is. Maybe I am number 7 now, but in terms of understanding what is in that thing, and particularly if it's going through the plan making process, there may be a new incoming one. It's awfully difficult. It's hours of time to properly understand it. Right, I'm going to very quickly, because we've got just about 15 minutes or so, talk through the subject property. So Paul's talked around the subject property, and I'll talk a bit about the subject property. And this is a cut down version of an hour's long talk that I give sometimes to our lawyers at VWV, the property lawyers, about planning for property lawyers, I guess, is what I normally call it. So the source of planning due diligence, and we're talking about subject property here. Generally, one relies on the replies to inquiries from the council and local land charges search, the replies to inquiries from your seller, and a bit of your own research if you're up for that sort of thing. So the problem is, though, it is a story of inconsistent paperwork. Oh, and I've gone, I do apologise. So yeah, I thought I was on the wrong slide. A story of inconsistent paperwork. So particularly for older permissions, there may be very little on the website. There may be missing information out the local authority replies. But there should be enough, a potted history at the very least, on the website or in the replies from the local authorities to give you a starting point. It is definitely worth reading all the way to the end. It sounds a bit trite, but further on through the local authority replies, there may be things like an Article 4 direction, a notice about that, and an Article 4 direction is definitely worth reporting on to your clients because these restrict the availability of permitted development rights for the subject property. My camera has disappeared. I'm back. And not only physical development, this may also restrict the ability to change the use of the property. You should also push for proper replies to inquiries from the seller. Hopefully, most conveyancers do this anyway, but the reply, rely on your own searches, is just so desperately unhelpful. It's really unhelpful from a planning point of view because it's not just the information that is verifiable from third parties that is relevant. It is the history of that property, the use to which it has actually been put, maybe even in breach of planning, or the changes that have been made to the site, again, maybe in breach of planning, all form part and parcel of the planning title. To establish which permissions might be relevant, I tend to work from the newest to the oldest, I suppose, with the hope that one hits the relevant permissions first. As the years go by, every single property in the UK is gaining more planning information. It's becoming more difficult. It's becoming more lengthy. But one should remember that don't just stop when you get to the first relevant looking permission. There may be two relevant permissions. There may be a permission for the use. There may be a permission for the physical development. There may be more than one permission for the physical development. Be aware that not all permissions may have been implemented. It looks like you may have hit upon the right one, but of course, if there were two for similar developments, you may not know which has been implemented. Reading again a bit through the local authority replies, you'll get some more information about whether there are any Section 106 agreements. And in the local land charges search, there should be Section 106 agreements, again registered, but also any discharged community infrastructure liability. You need to report on those. You might end up with, and I think this will, as time goes by, we end up with several entries, perhaps sometimes for developments that have not been implemented. So they do require a little bit of thought and working through. So having established which permissions and Section 106 agreements are relevant, what next? Well, one will usually be reporting on the conditions attached to a permission. So the structure of a planning permission, when you open it up and got it in front of you, there's a description at the top, which is describing what that property, that development is, in very brief details. 3-story house, or use as a cafe or something. And then you'll normally find, and I'm sure you're used to this, several pages of conditions. You generally are looking through to see whether those conditions are discharged and reporting not only on whether they have been, whether they've remained to be discharged, or also, and they may not be once and for all conditions, they may carry on for the lifetime of the permission. So what will conditions do? Well, they might restrict future development. They might remove PD rights, permitted development rights. They might prevent you from enlarging the property even under PD rights. They may restrict opening hours. They may restrict the type of glazing you use, and so on. All of these things are obviously relevant to somebody purchasing the property. Returning again to inconsistent paperwork, this is the real problem with conditions. And this is really where one should push the seller to give you a bit more information about what might have happened, particularly if their seller is a developer. The real problem in the UK system is that there some planning applications, some applications for discharge of conditions are noted on the planning file. You'll see that on the website or the replies from the local authority. Some are ongoing for opening hours, so there will be no evidence of compliance or discharge. And some councils in particular, but some types of conditions are self-certifying. So, for example, if a condition might require maybe even a payment of some of money or approval or something, and the council just won't give over that information. They'll say you'll have to ask the applicant, the seller, for evidence that this has been done, evidence that a payment has been made, evidence that they went and got the council's approval. It's really an unhelpful situation, but you know that is the way we've got to. Conditions can be the subject of enforcement by the local planning authority, a breach of condition notice, and so the liability for complying with these conditions survives with the land. So if the purchaser of property will need to either rectify the problem if there is one, or be subject to a potentially a breach of condition notice. Section 106 agreements often cover similar ground to conditions. Again, so payments of sums of money or restrictions on the use of the property. At a basic level, they are just contracts between the landowner and the council. By virtue of Section 106, they run with the land. They should be registered on the local land charges register. One thing to note is that they don't expire. Even if a Section 106 was entered into in respect of a particular permission and a subsequent permission was granted and that subsequent permission was implemented, that original 106 doesn't necessarily die. It might stop being enforceable by virtue of its own interpretation. So we're talking about contractual interpretation here. There may be a clause in it that restricts it only to that particular permission, or the obligations in it may be so wide that they carry on. And this is particularly, one has to be careful where that original permission was implemented and maybe say 20, 30 years later, one goes for a new development. That old Section 106 agreement, or Section 52 if it's particularly old, will survive. I do apologise, my video is turning itself off. One good example of this is I saw a property acquired by a developer. It was a single building on a plot that contained two separate buildings. It had been previously developed with a car park on the ground floor. For the sake of argument, let's say it had 40 spaces. The original Section 52 agreements, we are going back some 30, 40 years plus, said that those car parking spaces were split unevenly between the two buildings. One building had let's say three quarters of them, and the other building being the office block had 1/4 of the spaces, and that the properties had to stick to that. The developer buying the office block with the intention of converting it to resi had acquired with that office half the freehold of the ground floor, half the spaces they owned. The council said, you cannot change it. We are sticking with the original Section 52 agreement, not least because the people that lived in the other block complained. Therefore, despite owning half the spaces, the council's planning system through that old Section 52 agreement required only 1/4 of the total spaces to be available for the new building. They can bite, even if old, even with a later permission. Right. A Section 106 agreement generally will be can be enforced by injunction, and that's notwithstanding the usual rules about injunctions, because it's Section 106 itself says that planning obligations are enforceable by an injunction. So you might think, oh well, damages will be an adequate remedy here. That rule is supplanted by the fact that an injunction is the primary way of enforcing it. This is partly because actually, from a council's point of view, damages are a pretty useless remedy in many cases. In interpreting what's left to do in a Section 106 agreement, watch out for preoccupation conditions. Developers are not always great in working through all of those in their rush to get some properties on the market. Look out for obligations that are jointly owned by more than one property owner, where, for example, Section 106 covers a larger area which has been divided up. Are those obligations still capable of being complied with by individual owners? And as I said at the end of the slide, check on how this is going to affect the capable use of this property. Listed buildings and conservation areas cause a real headache, really. So listed building consent is a separate consent. So you should see for each physical development or even potentially change of use on your replies from the local authority to consents. It should be noted, and it's probably worth reminding people in your reports on the acquisition of property, that it's an offence to carry out works that require listed building consent without getting the consent first. It is interesting to note that not all works to a listed property will require listed building consent, because those works need to affect the character of the building as a building of special architectural or historic interest, though I would always err on the side of caution to suggest that perhaps one should at least speak to the council, if not apply for listed building consent. They can always say, you don't need this. Get it wrong, of course, it's a criminal offence. Acquiring a building that has had changes to it, a listed building that has had changes to it, well, the purchaser will not be liable for the offence of having made those changes without consent, but the purchaser, the new owner, may be liable to reinstate the property. So that is the financial liability that comes with those alterations that have been made unlawfully. If the council takes the further step of issuing a notice, an enforcement notice, then not complying with the enforcement notice is itself a criminal offence. In looking a little bit wider, and the planning data from the reports obviously will help with this, that development in the setting of a listed building next door or next door but one, or in fact quite a long way away, depending on how important that building is, development in the setting of a building is likely to be subject to additional policy considerations upon future development. And that, as I say, quite a long way away, it can be quite extensive when it comes to views of that listed building. I recall a development whose name just escapes me on the north side of the Thames in London, being stymied by the views from Kew Gardens, Kew Gardens being comfortably on the south side of the Thames. So it was good 800, 900 meters distance. So the sort of policy net cast by Kew Gardens for consideration on development is massive. Conservation areas, I'm very briefly going to touch upon. Conservation area consent is and hasn't been for quite a few years now, quite frankly, a separate type of consent, but it is a relevant consideration in planning applications. Demolition in conservation areas, certain buildings and structures may require conservation area consent before they are demolished. One should always watch out that trees in a conservation area have some added protections. And finally, and this very much with the Withers case in mind at the beginning, which is don't be tempted to answer off the cuff The answer being, don't worry, that breach of planning has been there for 10+ years. Don't worry about it. Immunity from planning enforcement is an extremely useful situation to find oneself in when it comes to breach of planning. For change of use to a single dwelling house or for operational development, like physical development, that time period is 4 years. For material change of use or breach of condition, it's 10 years. Why do I say don't be tempted to go for an off-the-cuff answer? Well, there were lots of little nuances to that. For example, particularly for operational development, it mustn't have been hidden. There was the case of that farmer who built his castle and hid it behind hay bales for 4 years. That still needs to be demolished. Breach of condition is the real one that can catch you out, because it is not a permanent immunity once that 10 years has passed. If you start complying with that condition again, then the immunity disappears. Great example of this is a holiday home. Holiday homes often come with conditions attached to their planning permission that they must be used, say, for only 10 months of the year to prevent somebody living there permanently. Several times in the last few years, I've had these come past my desk where somebody's looking to acquire one of these properties and the seller has been living there permanently. Maybe you've been living there permanently for 10, 12, 15 years. The problem is if you then start complying with that condition again, i.e. you casually use it as a rental property again, or in one case I recall that the seller had actually moved out for 2 months. Technically, you've been complying with that condition again. The immunity disappears. The condition comes back to life. That can have quite a dramatic effect on value. I'm not going to cover certificates of lawfulness, not quite enough time, but they are, I suppose, they are the definitive way of ensuring that your intelligent guess that it is beyond enforcement is a good way of resolving it. Or I should say on certificates, and obviously they land on my desk from transactions from time to time, is that they're going to take up to 8 weeks once the application has been put into the council. So you need to leave 10 to 12 weeks perhaps to make a certificate and get an answer. And 10 to 12 weeks is a long time in a conveyancing transaction. So I do always urge my property colleagues to come to me earlier rather than later. And that is that.